I vaguely remember this guy's face. I think he's probably logged in for the wrong day.
I'm guessing that's on my page.
Okay, then I starting our audio. We're moving on. Okay. We're back on the record in the matter of the people of the state of Michigan versus Jamal Hamade, file number 20-02002SM. Council appearances.
Thank you, Your Honor. Aaron Hosfield on behalf of the people.
Senator D'Angelo, and the standby counsel for Mr. Amati, who's present, standing in the courtroom.
Jamal Hamadi, Your Honor.
Thank you. Mr. Hamade is, has elected to proceed in pro per. We're going to prepare to call the jury back in. I just wanted to make sure we didn't have any preliminary matters before we do that.
The only thing that I think has at least come up and warrants a court's ruling, Your Honor, is whether should a witness choose to testify without a mask, that will be allowed by Your Honor.
That will be allowed. Yeah, I actually probably would prefer it just so that we could hear. We've been struggling to hear people, so that's fine.
Understood. Thank you, Your Honor.
No
Nothing
problem.
further.
Any objections for that, sir?
No, Your Honor.
Okay, thank you. Give me just a moment. I gotta make sure I have the right instructions in here. Okay.
Sure, thank you.
Okay, you can be seated. Thank you. And I want to thank you all for coming back from lunch promptly. Okay, ladies and gentlemen of the jury, you have been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duties to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. Can you please rise and raise your right hand? Do each of you do solemnly swear or affirm that in this action now before the court, you will justly decide the question submitted to you, that unless you are discharged from the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of this court? Thank you. You can be seated. I will have a written copy of the instructions I'm going to read to you, and you'll be provided those when you go for deliberation. You may refer to them during the trial. Since no one can predict the course of the trial, these instructions may change at the end of trial. At the close of the trial, I will provide you with a copy of my final instructions for you to use during your deliberation. A trial follows this procedure. First, the prosecutor makes an opening statement where, in this case, she gives her theories about the case. The defendant's lawyer, or in this case, the defendant who is representing himself, does not have to make an opening statement, but he may make an opening statement after the prosecutor makes hers, or he may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. To prove the charges, the prosecutor must provide the following reason, must prove the following beyond a reasonable doubt. Give me just a moment because I don't see where that's in here. Okay, so first, that the defendant did maliciously use a telecommunication service or device provided by a telecommunication service provider to communicate with Adam DeLay. Second, that when communicating with Adam DeLay, the defendant A, threatened physical harm or damage to any person or property in the course of a conversation or message through the use of telecommunication service or device, or B, used vulgar, indecent, obscene, or offensive language, or suggested any lewd or lascivious act in the course of a conversation or message through the use of a telecommunication service or device. Third, that the defendant did so with the intent to terrorize, frighten, intimidate, threaten, harass, molest, or annoy Adam DeLay, or disturb the peace and quiet of Adam DeLay. Next, the prosecutor presents his or her evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant or his lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of her evidence, the defendant may also offer evidence, but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant or his lawyer will make their closing arguments. Like the opening statements, these are not evidence. They're only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. You will be given a copy of the instructions I have just read to you. You may refer to them when you're in deliberations because you won't get them until then. Since no one can predict the course of this trial, again, these instructions may change at the end of the trial. And at the close of the trial, you will be provided with a copy of my final instructions for your use during deliberations. I will now explain some legal principles you will need to know and the procedure we will follow for this trial. Defendant is charged with 2 counts of telecommunications services malicious use. In order to prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. We just read that. There's the elements. Again, the elements are: first, that the defendant did maliciously use a telecommunications service or device provided by a telecommunications service provider to communicate with Adam DeLay. Second, that the communicating with Adam DeLay, the defendant threatened physical harm or damage to any person or property in the course of a conversation or message through the use of a telecommunications service or device, or used vulgar, indecent, obscene, or offensive language, or suggested any lewd or lascivious act in the course of a conversation or message through the use of a telecommunications service or device. Third, the defendant did so with the intent to terrorize, frighten, intimidate, threaten, harass, molest, or annoy Adam DeLay, or disturb the peace and quiet of Adam DeLay. A telecommunications service is a system for transmitting information by any method, including electronic, electromagnetic, magnetic, optical, photo-optical, digital, or analog technologies. A telecommunications access device is any instrument, including a computer circuit, a smart card, a computer chip, a pager, a cellular phone, a personal communications device, a modem, or other component that can be used to receive or send information by any means through a telecommunications service. A telecommunications service provider is a person or organization providing a telecommunications service, such as a cellular, paging, or other wireless communications company, or a facility, cell site, mobile telephone switching office, or other equipment for a telecommunications service, including any fiber optic, cable television satellite, internet-based system, telephone, wireless, microwave, data transmission or radio distribution system, network or facility, whether the service is provided directly by the provider or indirectly through any distribution system, network, or facility. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about the evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the case or the facts of this case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. It is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you have based on race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? The questions the lawyers ask or the questions that the defendant will ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers or the defendant in this case asks the question that assumes or suggests that it is. I may ask some of the witness questions myself. These questions are not meant to reflect my opinion about the case. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand these facts in the case. You are allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, do not ask it yourself. Raise your hand, write the question down. You've been provided notepads. You can write the question down and you'll pass it to my court officer and he will give it to me. Do not show your question to the other jurors. If your question is not asked, it is because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answers to questions submitted by members of the jury. On the other hand, if you cannot hear what a witness or lawyer says, please raise your hand immediately and ask to have the question or answer repeated. During the trial, the lawyers may or the defendant may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My ruling for or against one side or the other are not meant to reflect my opinions about the case. Sometimes the lawyers and I have discussions out of your hearing. Also, while you are in the jury room, I may have to take care of some matters that have nothing to do with this case. Pay no attention to these interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all the jurors are there. When the trial is over, you may, if you wish, discuss the case with anyone. If I call for a recess during the trial, I will either send you back to the jury room or allow you to leave the courtroom on your own and go about your business. But you must not discuss the case with anyone or let anyone discuss it with you or in your presence. If someone tries to do that, tell him or her to stop and explain that as a juror, you're not allowed to discuss the case. If he or she continues, leave and report the incident to me as soon as you return to court. You must not talk to the defendant, the lawyers, or the witnesses about anything at all, even if it has nothing to do with this case. It is very important that you only get information about this case in court when you are acting as the juror and when the defendant, lawyers, and I are all here. The restrictions I'm about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that the jurors are not influenced by anything or anyone outside the courtroom. Now that many jurors have easy access to information through handheld devices and other technology, jurors may be tempted to use these devices to learn more about some aspect of the case. But if a juror were to do this, it would harm the parties. The parties and their attorneys would have no way of knowing what a juror has gotten. Just a moment. The party's attorney would have no way of knowing that a juror has gotten outside information and would have no chance to object if the information was false, untrustworthy, or irrelevant. Remember, no matter how careful and conscientious news reporters, family members, friends, and other people outside the courtroom may be, the information about the case from television, radio, or internet and social media will inevitably be incomplete and could be incorrect. Please bear these things in mind as I read the following instructions. These restrictions apply from this moment until I discharge you from your jury service. You must decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that during the trial, you must not read, watch, or listen to news reports about this case, whether in the newspaper, television, or radio, or on the internet. You also must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as search with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigations or experiments using the internet, computers, cellular phones, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. Before your deliberations, you must not discuss this case with anyone, even your fellow jurors. After you begin deliberations, you should discuss the case with your fellow jurors, but you still must not discuss the case with anyone else until I discharge you from jury service. Until I have discharged you from jury service, you must not share any information about the case by any means, including cellular phones or social media. If you discover that a juror has violated my instructions, please report it to my court officer. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide the verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. You must turn them over to the court officer during any recesses. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. In this case, the defendant, Jamal Hamade, is representing himself. This fact should not affect your decision in any way. The defendant has the right to represent himself, and he has chosen to exercise that right. A lawyer, Dan Doyle, is present if the defendant wishes to consult him. You can see that we have chosen a jury of 7. After you have heard all the evidence and my instructions, we will draw lots or names to decide which one of you will be dismissed in order to form a jury of 6. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial, and at the end of trial, I will give you detailed instructions about the law in this case. You should consider all of my instructions as a connected series. Taking all together, they are the law you must follow. After all of the evidence has been presented and the lawyers have given their arguments, or the defendant has given his argument, I will give you detailed instructions about the rules of law that apply to this case. Then you will go to the jury room to decide your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not take or make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors, who may have different backgrounds and perspectives from yours. Okay, prosecution, you can call your first witness.
May I make an opening statement, Your Honor?
You may, oh, I'm sorry. You may
Thank you.
be open. Yep.
Thank you. Ladies and gentlemen, Good afternoon. As the judge said, the way that this trial will proceed is that I will make an opening statement. I will then call witnesses. I may introduce an exhibit. The defendant will have the opportunity to ask questions of the various witnesses that are called. The defendant may or may not choose to testify. At the conclusion of the trial, I will be standing before you again to essentially walk through what I believe that the evidence showed and how I think those are important elements of this case. Now, I understand that this is a lot of information that is being thrown at you right away. I also understand that this case involves some very long definitions. I hope to be able to walk you through and have a better understanding so that as you sit here this afternoon, you're able to focus in on what it is that your job requires as the jury. So to simplify things for you, what we have is the defendant has been charged with 2 counts of telecommunication services malicious use. And that is a very fancy way of saying maliciously using a telephone. Now, the reason that there are 2 counts of the same offense is because the people are alleging that these offenses occurred on 2 separate dates. So you will hear testimony as it relates to one date, which is July 18th of 2019. You will hear testimony of the second date, which is August 16th of 2019. Beyond those 2 differences, the charge remains the same, the elements remain the same, and the person, Adam DeLay, remains the same. What that means for you as jurors is that when it comes time to deliberate, you may treat these as 2 separate cases, as if we had totally different charges. What that means is that you may decide as a group that I have met my burden as it relates to one date, but not the other, and that's okay. I firmly believe that the evidence will support both, but it is not an all or nothing. You will be instructed that these are 2 separate charges, and the jury verdict form that you receive will allow you to make decisions as it relates to both. So now what is it that you are going to be considering? You heard the judge describe the elements. And the way that I like to think about the elements in any criminal case is like a checklist. So we know that I carry the burden in this case. We know that this is my case to prove beyond a reasonable doubt. And the way that I do that is I start with that checklist and I work my way through. So what I'm going to ask you to keep in mind as we sort of sift through all of this is first that the defendant did maliciously use a telecommunications service or device provided by a telecommunications service provider. Take all of that out, put in phone. He used a phone. Those definitions that the judge provided you with all boil down to a phone was used. And he used it to communicate with Adam DeLay, one of the witnesses you're going to hear from today. The second element is that when communicating with Adam DeLay, he did one of 2 things. And again, this is going to be an and or. So the people are alleging that he either threatened physical harm or damage to any person or property in the course of a conversation or message through the use of a telecommunications service or device, phone, or that he used vulgar, indecent, obscene, or offensive language, or suggested any lewd or lascivious act in the course of a conversation or message through the use of a telecommunications service or device, phone. Third, that when he did that with the intent to terrorize, frighten, intimidate, threaten, harass, molest, or annoy Adam DeLay, or to disturb the peace and quiet of Adam DeLay. So this checklist gives you a lot of and-ors, and-ors. And that's important for you as a jury. Because to truly understand my burden means that you need to understand the elements. And that you need to understand that it's not all of it, right? I don't have to prove all of these things. I have to prove some of them in combination to the satisfaction of the jury. So when you go back to that jury room, some of you right off the bat may say, absolutely threatened physical harm. Absolutely, I heard it. I'm going with that. Some of you may say, no, but there was a lot of obscene or offensive language. I'm going with that one. That's okay. You do not all have to pick the same one. So I have to prove that he either or. So as a jury, you only have to come together to determine that together, all 6 of you that will go back, make a determination about one of them. And that's important. The other important part is that this conversation can occur either through a conversation or a message, meaning he does not have to contact and speak with Adam DeLay directly. Messages to Adam DeLay are sufficient under this charge. Another area where we have a lot of commas and ors is as we look at his intent. And you all remember just a brief hour ago, we sat here and said, let's talk about intent. We can talk about intent through actions, words, body language. Okay? So we have to establish the prosecution that he intended to terrorize, frighten, intimidate, threaten, harass, molest, or annoy. And you'll see those are all very different things. Or we can show that he disturbed the peace and quiet of Adam DeLay. There's a lot of information. You're going to get all of this in writing, which will help you as you sit down in the jury room to go through these cases. What I'm going to ask you to do as you sit here is to pay attention and don't get so caught up in these words. I'm going to get to go over them with you again, and you're going to have them in writing. I think it's more important that you stop and listen. You're going to hear from 2 witnesses today. One is Mr. Adam DeLay. He is a former employee of the governor's office of the Constituent Services. He's going to explain to you what that means, what that role is. He's going to tell you that in the summer of 2019, in July and August, he received a series of voicemails that, based on the severity of the voicemails, the frequency of the voicemails, the content of the voicemails, a decision was made to report those to an outside service. You're going to hear those voicemails. We have the benefit in this case of being able to actually hear the words of Mr. Hamada. So it's not a he said, she said. You all are going to be able to make the decision about that intent because you're going to hear it yourselves. Now, the agency that was brought in to investigate when it was determined that this was going to be taken outside of the governor's office was the Michigan State Police. So you are going to hear from Sergeant William Lutz of the Michigan State Police. Back in 2019, he was a detective assigned to federal and state crimes involving certain types of buildings, locations, or offenses. He's going to tell you that he met with Mr. DeLay. He received those voicemails and then walk you through his investigation based on the name that was left in the voicemail, the phone number that was used, and how he tracked that to Mr. Hamade, who is seated in the courtroom today. So I ask that you pay attention, listen to those voicemails, and decide based on what you have to determine at the end. Do we have threatened behavior? Do we have obscene conduct? Do we have specific intent as established here? And I think very strongly that at the end of the day, after listening to the evidence provided to you in this trial, that you will find that the just verdict in this case is going to be guilty on each count. Thank you.
Mr. Hamani, did you want to make an opening statement?
Yes. Good evening, jury. I want for the record, formally state, I, the defendant, Jamal Hamadi, did not have malicious intent to terrorize, frighten, intimidate, threaten, harass, molest, annoy, or disturb the peace and quiet of Adam DeLay. I may use vulgar language, but that was not my intentions. Not my intentions. No malicious intent to disturb his peace and quiet or to terrorize him or frighten him. I had a purpose to call, and I was turned down. It was just that I called him.
Mr. Hamani, I'm going to redirect you. This is not your time to give testimony. This is your time to make an open statement about any information or any evidence that you intend to present. I see you speaking to someone back there. That is not your attorney, sir.
I speak to nobody.
I saw the communication myself, so you need to be careful that you're not communicating during the court proceeding, okay?
Not communicating.
Okay, so I need you to only give your opening statement about the evidence you intend to present, okay? And the outcome that you are hoping to come out of it. But this is not time for testimony. If you would like, you'll get an opportunity later to take the stand for that.
It's just there was no malicious intent. It was purpose driven. That's all.
Thank you. You can call your first witness.
Thank you, Your Honor. The people would call to the stand Adam DeLay.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
And you can have a seat there. Okay, so there's a microphone in front of you. I have a court reporter sitting next to me. She has to take down everything that's being stated here today. So all of your responses need to be loud enough so we can hear. And then they need to be verbal head nods and shakes, cannot be written down. So we need to hear a yes or a no. And try to avoid mm-hms, no-hums, because those can get confusing in the record. Can you please state your first and last name and spell it for the record?
Adam DeLay, ADAMDELAY.
If you can proceed, counsel.
Thank you, Your Honor. Good afternoon, sir. And could you state for the record, what is your current occupation?
Currently, I work as a legislative analyst with the Department of Health and Human Services.
And was that your occupation on July 18th of 2019 and August 16th of 2019?
No.
And were you employed over the course of those dates?
Yes.
Where were you employed?
I was employed in the governor of Michigan's office.
And what specifically was your role within the governor's office?
Yeah, my title was Deputy Director for Constituent Services.
And what is constituent services, sir?
Sure. Constituent Services is a branch of public service and elected officials' offices that deal with the general public. So it may involve, for example, answering phone calls for individuals that may be having trouble with a branch of state government, for example, somebody who may be having issues with their Medicaid, food assistance, etc., as well as taking down calls or opinions that constituents may have about a bill or some sort of issue, maintaining email and letters, correspondence, etc.
And where is this office located?
It's located in the Romney Building, which I believe is 111 South Washington, or Capitol Avenue.
Is there a voicemail? I'm sorry, I'll ask, so as it relates to 2019, when you were employed there, I don't know if you would know now. Back in 2019, when you were employed in that capacity, was there a voicemail system?
Yes.
And during the summer of 2019, those dates, July 18th of 2019 and August 16th of 2019, did you receive a series of voicemails that were eventually reported to someone else?
I don't know the exact date specifically, however, that did occur within roughly that time frame. Yes.
And who were those voicemails reported to?
They were reported to my immediate supervisor, which was Scotty Barton, Director of Constituent Services in the Governor's Office.
And I imagine that you receive a lot of phone calls, voicemails, just based on your job description as you provided it today. Is that correct?
That's correct.
And why is it that a decision was made in this case to refer these voicemails on?
Sure. So we had individuals who had, so I should say, I receive voicemails myself, and then we have a general voicemail system that at the time was checked by staff in our office on a rotating basis. So staffer A may check it one day, staffer B. So due to the volume of voicemails we received in this case, or the number of calls that we were getting in succession, as well as the content of it, which tended to be loud, abrasive language. Because of that, it was determined by some of the staff in the office to alert the director of the department or the division that we were receiving these contacts.
Now, to be clear, this conversation or this incident, as you're describing it, they were all voicemail-based conversations. Is that correct?
I do believe that there were instances where,
As it relates to you.
as it relates to me, yeah, I believe the only thing I ever received was a voicemail. That's correct.
Very good, thank you. And it wasn't just one, there was a series of voicemails, is that correct?
I received one on my individual voicemail. The others were received in the general mailbox that we have for the governor's office.
As it relates to both the July date and the August date?
I honestly don't recall. I know for sure I received one of them. My understanding is the others were received in the general mailbox. I could be incorrect.
And what did you do with the voicemails?
I preserved them. I recorded one on my cell phone, and also the state police came and recorded them as well.
And when you say you preserved them, did you do anything to alter the voicemails?
No.
Did you do anything to change the voicemails?
No.
Did you speak with anyone specifically in law enforcement?
Yes,
And who is that?
Detective Loops.
Did you provide the voicemails to Detective Loops?
Yes, he recorded them.
And the voicemails that were recorded are again in the preserved state as they were received.
Correct.
And at this time, I would move for admission of People's Proposed Exhibit Number 1. It is a flash drive containing a series of voicemails. They will be designated as People's Exhibit 1A, 1B, and 1C.
Any objection?
Only if the audio recording is in full.
I'm sorry, can you speak up for me?
Only if she played the audio recording in entirety.
Okay. Is there an objection to her playing? We've discussed this prior to going on the record, so my ruling on that has already been given. So is there an objection at this time?
It'll be my objection.
Okay, so the objection is overruled. People's Exhibits 1A, you said 1B and 1C?
That is correct, Your Honor. It's simply one flash drive that
Okay.
is labeled 1, and within it there will be a variety of messages.
Okay, People's Exhibit 1 will be admitted.
Thank you, Your Honor.
I do object for authentication too.
Okay, your objection is noted,
Thank you, Your Honor.
but overruled.
Your Honor, at this time, I will be playing the voicemails. Your Honor, I'm going to take a guess at the appropriate volume. If it appears far too loud or far too quiet, I will stop and readjust the volume.
No problem.
Thank you.
I pray to God to kill Governor Winthrop and that stupid ass vice president and his stupid ass white bitch. I pray to God kill y'all motherfuckers. Y'all gonna kill my uncle in prison. Just want to uphold a stupid ass bitch man white boy law. You white people are the worst race ever. I hate y'all bitch. Y'all stupid motherfucking white people. I hate y'all. I hate white people. I hate y'all motherfuckers. I hate you. You stupid white bitch. Fuck Governor Woodson. That stupid ass dumb-looking bitch. Let my fucking uncle out of prison.
Received July 18th at 11:22 a.m. To repeat, press 4 for deleted. Message 2.
Bitch, you stupid ass bitch. You stupid ass hoe. You stupid ass government. You stupid ass government. Y'all bitches killed Jesus. I hate y'all bitches. Y'all locked my uncle up over a whole ass gun. After the Constitution said we can have guns. You stupid ass white people. I hate y'all bitches. I hate y'all. I pray to God just do it fucking. I hate y'all motherfuckers so fucking bad. Fuck you, you stupid white shit. You shitty ass white motherfucker. You dumb ass racist people. You fucking cover of all dirt shit, nigga. You fucking third blocker looking motherfucker. Yo dumb ass race. You dumb ass white people. You dumb ass shitty ass white people. I hate y'all, bitch. Let my fucking uncle out of prison, bitch.
Received July 18th at 11:24 a.m. To repeat, press 4 for message properties, 5 to forward it, 6 to delete it, 7 to reply, 8 to save it, 9 saved. Message 3.
For purposes of the record, that is People's Exhibit 1A. I played from the beginning of the message until 24 seconds by the timer. I then played from 32 seconds to the end of the message.
Thank you.
Whatever your name is, after delay or whatever. My name's Muhammad. I'm calling in regards to my uncle. That nigga in prison right now for a fucking gun charge. A fucking gun charge. And he get over it. He ain't shot nobody with it. Y'all motherfuckers ain't got no ballistics on that nigga. Then you got bodies on that motherfucker. You ain't got no bodies on that nigga. You ain't got no victims complaining on that nigga. It's just a bunch of bitch ass white people whining like some bitch ass white people. And this nigga going over a fucking half decade. And this nigga about to die in prison. And you want to uphold your bitch ass white ass bro to keep my motherfucking uncle in prison? You hoe ass white people. You hoe ass white people. Y'all the fucking stupidest, lame bitch ass race of all times. Y'all the worst motherfuckers ever. The Bible says
message properties, 5 saved.
I wanted my uncle to let that nigga out the joint right now, bitch. Back the fuck out. Let that nigga out the joint. You know what I'm saying? Get that nigga the party. Let him out. He's doing 20 years for a punk ass gun. He ain't getting no unlawful discharge. He ain't aiming at nobody. Y'all unlawfully, without a warrant, kicked down his damn door, nigga. Found the gun in the fucking attic. And he just carried it on him. Cause y'all fucking evil ass white people. Y'all white people evil. No. This is proof that y'all white people evil. This is proof. Y'all little bitch ass white Jesus. That nigga look like a pussy, Lord. Who the fuck gonna be a savior? And that nigga look like a straight hoe. Old ass white Jesus. That nigga look like a straight up bitch, dog. And then you even read the Bible in Revelation. It said that nigga had a skin color of brass. Brass. What's the color of brass? It's way darker than that soft ass white boy, Lord. That soft ass white boy. That's what your niggas is. Stupid ass white people. Fuck you.
Received August 16th at 12:37 p.m. To repeat, press 4 for message property.
For purposes of the record, Your Honor, that was People's Exhibit 1B that played from the beginning of the timer through 2 minutes and 0 seconds. It then played from 4 minutes and 57 seconds through the end, which is 6 minutes and 12 seconds, Your Honor.
Thank you.
And y'all motherfuckers just treat niggas like shit, cause y'all some racist, evil ass white people with your faggot ass Jesus. That faggot ass white Jesus. That nigga look like a straight bitch. How the fuck that nigga destroy evil and that nigga look like a fucking faggot? That nigga say gonna do a second coming and fuck this evil up. How the fuck you gonna fuck up evil? That nigga look like a faggot, dog. You look like your bitch ass. Fuck you, man, nigga. Fuck your polite talk, nigga. Fuck you. Y'all fuck my life up, Michigan, and I'ma cut it to y'all motherfuckers every chance I feel like it, nigga. Fuck you.
Received August 16th at 12:42 p.m. A message from 31333387616. Received August 16th at 12:42 p.m. Invalid selection. Try again. A message from 31333387616. Received August 16th at 12:42 p.m. To repeat, saved. Message 4.
Fuck you ain't picking up the phone, nigga. Know what I'm saying? What the fuck you mean? Pick up your motherfucking phone, dog. You what the fuck you a government employee, dog. Your job is to serve us niggas, dog. Know what I'm saying? Pick up your motherfucking phone, dog. Ass white ass Jesus, nigga. Y'all lied to us, nigga. So much that's Jesus, nigga. And the Bible said that nigga cutter a branch, nigga. And you gonna show us a soft ass white boy Jesus, nigga, like a straight up pedophile, nigga. Nigga look like hate it, nigga. God hates y'all white motherfuckers. Who come out white, dog? Who? When y'all soft ass white boys get famous, don't y'all bitches get red, motherfuckers? Who come out red, motherfuckers? Y'all white people. Y'all lied to us talking about God loves everybody, nigga. God don't love everybody. God hates y'all soft ass white people, dog. God hates y'all white people. Y'all treat us like shit, nigga. Y'all treat everybody like shit, nigga. The whole fucking world don't like y'all white folks, nigga. You stupid ass white bitch.
Received August 16th. A message from 31333387616. Received August 16th at 1:05 p.m. To repeat, press saved. End of saved messages. You have no new messages. To send a message, press.
And that last voice message, Your Honor, was People's Exhibit 1C. I began playing it by the timer at 1 minute and 43 seconds through 3 minutes and 18 seconds. It was resumed, Your Honor, at 3 minutes and 28 seconds through the end, which is 5 minutes and 31 seconds.
Thank you.
Thank you. Mr. DeLay, part of your job then, in your role as Deputy Director and the entirety of the constituent services, would be to process a constituent's concerns or complaints. Is that correct?
That's correct.
And very often, I would imagine, you receive a communication in the form of written communication,
Correct.
phone communication.
Correct.
Do you allow for walk-in communications?
Yes.
And in those cases, someone would have the opportunity to sit down with you or one of the other staff members. Is that fair?
It would occur in the lobby. And what would happen is if an individual came in off the street as a walk-in, what would happen is that they would report to the security desk. The security desk would then call us, and we would come out to them in the lobby in the presence of a security guard.
Or if the communication came in the form of a phone call, a staffer might return a phone call. Is that fair?
Correct.
Or if it came in the form of a written communication, would either email, if it was an email,
Yes.
or might, would you provide a written communication back if it was a letter, or would that be a telephone call?
Generally, we would respond in the manner in which we were contacted, depending on the nature of the communication. If it was something that was urgent or a problem that was written to us and there was a phone number, we may, for whatever reason, decide to call if we had additional questions or it involved more heavy legwork.
Certainly. And this is, by its very nature, a back and forth. Is that correct?
Correct.
Okay. But it is when that concern or complaint is able to be processed and addressed by someone within your office. Is that correct?
I'm sorry, could you repeat?
Sure. What I mean to say is follow-up would be provided if the concern or complaint that came in is something that could be addressed by your office. Is that correct?
Generally, we will respond to any communication that would come into the governor's office. If it was not within our purview, we would send them a referral to wherever they needed to go.
But the voicemails, as we've heard them, was there something in all of this that could be responded to?
Yes, in this case, the constituent was contacting us because they were upset regarding what they believed to be unlawful imprisonment of their uncle. And so in a case like that, how we would normally respond is we would refer the constituent and educate them on the pardon and commutation process and let them know how an individual could apply for a pardon or commutation.
Did that happen in this case?
It did not.
Why?
Because of the nature of the constituents' calls as well as their voicemails and the inability for us to respond or have a conversation with the individual, we were unable to share the information that we normally would share in response.
Thank you. I have nothing further for this witness at this time, Your Honor.
Thank you, Mr. Marta. You may cross-examine the witness.
I have about 10 with any questions.
You stand back there, Chair.
Have we talked before?
We have not.
Have we ever met personally?
No.
So only the voicemails is what you know about me of.
That is correct. Well, beyond you do. Yes.
Do you know the context of the voicemail?
In the sense that if you're referring to contacting us regarding your uncle's case, that was my understanding of the context.
Do you know what I was thinking?
I do not.
Do you know any actions by me to carry out if it was any threats?
I know of no efforts to follow through on any threats whatsoever.
No efforts by me to do.
Correct. No efforts whatsoever.
That'd be all. Thank you.
Thank you. Redirect based on that.
Just very briefly, based on that last sentence, I'd like to clarify the question. You answered that you don't know of any. I want to be clear, any threats. I want to be clear that you're answering about whether he has the ability to carry out, as opposed to you have knowledge that he did not. Is that fair?
What I mean to say is to my knowledge, there was no action taken by this individual to follow through on any threats that were made to me or anyone in our office.
Thank you. I have nothing further for this witness. I would ask, Your Honor, that he remain in case I need him for rebuttal purposes.
Thank you. Does any of the jurors have any questions? Okay, thank you. So you can be excused to a private room, okay? Can you call your next witness?
Thank you, Your Honor. The people would call to the stand Detective Sergeant William Lubes.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
Thank you. Please have a seat there,
Thank you.
sir. And please state and spell your name for the record.
Sure. My name is William Lubes. My last name is spelled Lues.
Proceed, counsel.
Thank you. Sir, could you please state your occupation?
I'm currently a shift supervisor, a sergeant, in Michigan State Police at the Lansing Post.
And is that role, as you've just described it, the duty that you held on July 18th, 2019 and August 16th, 2019?
It is not.
And what role were you on those dates?
I was assigned as a detective at the state capitol for the state police on those days.
And what were your primary roles as a detective with the state capitol?
My primary role is to investigate crimes committed on state properties in the Lansing area, as well as those referred to the state police by state agencies in the Lansing area.
And were you asked to investigate a series of voicemail messages that were received by the governor's office, Department of the Constituent Services on July 18th, 2019 and August 16th, 2019?
That's correct.
And did you meet with anyone as a result of your investigation?
I met with several staff members at Constituent Services, including the prior witness, Adam DeLay, and the director of Constituent Services, Scotty Barton.
And what is the location of the Office of the Constituent Services?
Constituent Services is located at the Romney Building at 111 South Capitol, right here in Lansing, across the street from the courthouse.
Are you familiar with the Lansing city limits?
I am.
And is that location, 111 South Capitol, within the city of Lansing, county of Ingham, state of Michigan?
That's correct.
And when you met with Mr. DeLay, what were you provided?
Mr. DeLay played voicemail messages from his voicemail system on his desk phone for me.
More than one message?
That's correct.
And do you recall the dates of those messages?
The first two messages he provided to me were dated July 18, 2019. And the second set of messages he was not able to find in his voicemail system. He later emailed me those messages. The second two messages were dated August 16, 2019.
And did those messages, in addition to a date, include a time stamp?
That's correct.
Okay. And what, if anything, was noteworthy to you about the times of those messages?
The series of messages were received within minutes of each other on those particular dates.
Do you recall the times, sir?
The first set of messages on July 18th were received just before noon, and I can give you the exact time. It was 11:22 and 24:27, somewhere in that range.
Was there a third message from the 18th of July?
That's correct.
Do you recall the time on that?
I can refer to my report to give you the exact time if you don't mind.
Sure. Would it help to refresh your recollection? Do you have it there, sir?
I do.
Okay. If you want to pull that out, and I'll just make sure that you and I are looking at the same report. Would that be the Michigan Department of State Police incident number 16-199-19?
That's correct.
For the record, Your Honor, the witness will be refreshing his recollection from the report as I've just described it. Thank you.
So on July 18, 2019, a series of 3 voicemail messages. They were received at 11:22 a.m., 11:24 a.m., and 11:29 a.m.
And were the times also included, sir, for the messages on the 16th of August?
That's correct.
Okay. Would you need to refresh your recollection as to those?
Please.
Is it the same report?
That's correct.
Please do, sir.
On August 16, 2019, the messages were received at 12:37 p.m., 12:42 p.m., and 1:05 p.m.
Thank you. Now, did you receive those messages? You indicated some right at the time and then some at a later time from Mr. DeLay. Is that correct?
That's correct.
Okay. And have you also preserved those messages?
Yes, ma'am.
Okay. You heard the messages today. Is that a yes?
That's correct.
Okay. So the messages that I have played today, which are referred to as People's 1A, 1B, and 1C, are those the messages that you came into possession of as a result of your investigation?
That is correct.
Okay. And what, if any, identifying information came with those messages?
The messages came with a date and timestamp on the audio, as well as the last 2 messages arrived with a phone number.
And did you do anything with that phone number?
That's correct.
What did you do?
I researched the subscriber information and associated with that number.
Does law enforcement in the state of Michigan have a database where they can access information such as that?
So the Michigan State Police and most other law enforcement agencies maintain a report writing system where these things can be searched.
Okay. And so did you take the phone number that was listed? And to be clear, was it the same phone number that occurred in both messages that had a phone number attached?
That's correct.
Okay. And did you take that phone number and put it into your law enforcement database?
That's correct.
And what, if anything, did you learn?
I learned that the number was associated with Jamal Hamadi, the defendant in this case.
Did you receive any information about what type of device is affiliated with the phone number linked?
My belief is that it's a cellular phone. It's the last time I queried the number, it showed that T-Mobile was a service provider.
Thank you. And so you received the name Jamal Hamadi, is that correct?
That's correct.
And did you receive any other identifying information through the database?
I located an address, a name, birth date. I guess I'm not sure what database you're particularly referring to.
So the initial database, what you've just listed out, is that what came from the initial database?
Correct.
Okay. And then with that information, did you continue your investigation to determine more about the named person, Jamal Hamadi?
Yes, ma'am.
And what did your investigation, what did you do?
I conducted public record searches on the phone number through a database called TLO, and this strongly associated the number with Mr. Hamadi.
And when you say strongly associated, does it give you a number?
Correct. It will provide a range and a percentage. So for instance, it might say the number, and then 99%.
So in this case, did that number come back 99%?
It was a high 98, 99%. I don't recall the exact number, but it was one of those two.
Okay. And did you, through the course of your investigation, learn of social media accounts affiliated with the name Jamal Hamade?
That's correct.
Okay. And what specific social media accounts, the platforms, if you recall?
Sure. I located social media accounts from on Facebook, Twitter, Instagram, TikTok, LinkedIn.
And I will ask as a group, and then if we need to break them down, we may. But
Sure.
were you able to look at those social media platforms because they were public in nature?
That's correct.
And that would apply to all of those you just listed?
Yes, ma'am.
Okay. And did any of them have photos, a profile photograph associated with the account?
They did.
All of them? Or any in particular you can recall?
Facebook did. Twitter did. I'm unsure on Instagram. TikTok has a likeness in it. A lot of videos associated with those accounts.
Okay. And so let's talk about Facebook for a moment. Is there a profile picture on the Facebook account that you determined to be linked with Jamal Hamade?
Yes, ma'am.
And based on the photograph that's in the profile picture, do you see that person here in the courtroom today?
Yes, ma'am.
Could you please indicate for the jury the gentleman known as Jamal Hamade what he is wearing today?
Okay. Mr. Mahdi today is wearing a gray T-shirt over the top of a blue long sleeve shirt. He's wearing the paper blue mask, has a large beard.
Thank you, sir. Your Honor, may the record reflect that the witness has identified the defendant, Jamal Hamade.
Any objection as to identification?
No.
Okay, identification is noted without objection.
Thank you, Your Honor. Did you review the messages for content, sir?
I did.
And did you note that there was a particular person, a prisoner, associated with, through the threads of those voicemails?
Correct. The prisoner referred to in the voicemails is a gentleman named Lothario Triplet.
And did you do anything with that information?
I confirmed that there was a Lothario Triplet that was lodged with the Department of Corrections in prison.
And through your investigation as it unfolded, did you determine that Lothario Triplet is associated with Mr. Hamade?
I was not independently able to link him to Mr. Hamadi besides the content of the voicemails.
Did you link him to someone else affiliated with Mr. Hamade?
In a roundabout way, yes.
Okay. And who would that person be?
Clarice, I think it's Barrows or Burrows, the defendant's mother.
Thank you. And did you attempt to make contact with Mr. Hamade?
I did.
And what was your attempted contact?
Over the course of about 2 months, I attempted contact at his residence in Southfield approximately 4 or 5 times.
Were you ever able to make contact in person with him?
I never received an answer at the door when I knocked.
And did you ever speak with him over another form of communication?
I did.
And what was that?
I telephoned the number which was used to make voicemail messages to constituent services.
Okay. And did someone answer?
That is correct.
And did that person identify him or herself, or did you inquire who it was?
I asked if it was Jamal Hamadi. He advised he was Jamal Hamadi when I asked on the phone.
And did you speak with him about why you were calling?
I did.
And what did you tell him?
I advised that I was investigating threatening phone calls received by the Michigan Governor's Office and asked him to speak with me about that.
And what did he say?
He advised that he was pleading the fifth on the phone. He would not speak about it.
Thank you. Your Honor, I have nothing further at this time for this witness. Thank you.
Thank you. Mr. Amati, you can cross-examine.
When you was on the phone with me, did the defendant ever threaten you or curse you out?
You did curse me out. That's correct.
What else did we talk about?
15-minute conversation. It was mostly a rant with you yelling and cursing.
Any specific?
You did bring up some topics that I'm unsure I'm able to speak about this time,
Why not?
because it may result in a mistrial, I think.
So I'm innocent.
Your objection, Your Honor, I would ask that that be stricken from the record and that the court provide a instruction for the jury as to what the witness means and the outburst of the defendant.
Okay.
That was a
But
question.
Mr. Amati, you're to be questioning or cross-examining this witness. You're not to be making arguments or telling the jury that whether or not you believe yourself to be guilty or not, okay?
No, I was asking you.
I'm talking, so you're gonna wait for me to respond, okay? So the witness said he was not sure if he can respond to the question because he believed it's restricted because of the court rules. Okay, so you can follow up with that question or you can move on, but you do not need to now decide that you are going to be the trier of fact. That's the jury's job, okay?
Did you ever receive a voicemail of me apologizing?
I did receive an apology voicemail from you, that's correct.
Okay, that's my question.
Okay, it's for the record, the objection was sustained. I don't know if I stated that. And we will give a curative instruction before our deliberation.
Your Honor, thank you. I have no further questions for this witness.
Okay, you may be excused, thank you.
To return with me.
You can call your next witness.
Thank you, Your Honor. The people have no further witnesses and subject to any rebuttal, testimony would rest.
Back to ask the jury, do the jury have any questions for that last witness? Okay, thank you. Mr. Amati, do you have any witnesses that you would like to call, or would you like to put yourself on the stand? I am going to give you an opportunity to, if you would like, to talk to your standby counsel.
Can I make a motion for direct verdict?
Okay, you would like to make a motion? Is that what you're stating?
Yes.
Okay. I'm going to exclude the jury so that we can address the issues.
All rise for the jury.
Please be seated. Okay, Mr. Amati, you want to make a motion for directed verdict?
Yes, People versus Rutherford, in Illinois, respondent speech alone was not enough to establish criminal conduct.
Okay, is that all that you want to state to the court at this time?
Under MCL 750450E.
Any further arguments, sir?
The speech alone, because all it was in the testimony was just audio talk.
Okay, I've heard your argument. I'm just asking if you were complete or did you have anything else you want to say?
But that was it.
Thank you. Madam Prosecutor.
Thank you, Your Honor. The question of whether a motion for directed verdict is appropriate is based on the evidence as it stands at the time that that motion is made. In this case, certainly the court can make a finding and should make a finding that there is sufficient evidence to sustain a conviction and allow this case to go forward to the jury. The elements, I believe, have been covered ad nauseum, and I won't go through them again with the court, but I know that the court, looking at the elements, is able to ascertain based on the testimony of the two witnesses that have testified, as well as the exhibits 1A, 1B, and 1C, that this is an appropriate case to proceed to the jury to make a finding as to whether or not the intent, which I believe is what Mr. Hamade is arguing, is that for the conviction. So at this time, Your Honor, I would ask that the court deny the motion for a directed verdict and allow this case to proceed to the jury.
Thank you, Mr. Hamadi. Any further argument?
No, Your Honor. No, Your Honor.
Thank you. So the court does agree with the prosecution that the evidence as presented at this point is sufficient to continue to a jury. So the motion for directed verdict will be denied for those reasons. Okay, I'm going to take a 10-minute recess, and then you can decide or talk to your standby counsel if you'd like as to whether or not you want to call any
Your Honor, before the jury comes in, can we just determine if Mr. Hamada is going to testify so that I may release the delay if he is not?
Okay, can you let Nick know, wait a minute?
Sorry.
please? No problem. Okay, Mr. Hamada, did you decide whether or not you were gonna call any witnesses, including yourself, to testify?
Yes, me.
You're gonna take the stand? Okay,
Thank you, Your Honor.
no problem, okay. All rise for the jury. You can be seated. Okay, so, we're allowing the jury back in, the defendant did decide that you wanted to take the stand, so Mr. Hamada, you can approach the witness stand, please. When you get to the first step, I just need you to raise your right hand, okay, sir? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
In the book of Matthew, chapter 5, verse 33, Yahweh shall rule the world, even if he calls Jesus Christ, says, thou shalt not forswear. And go down
Or
to verse
affirm.
37. Verse 37 says, just make your yays be yay and your nay be yay. Anything else is going to be.
Okay, so do you solemnly affirm that you will tell the truth and the whole truth under penalty of
I say
perjury?
my word is, I keep my word. I
Okay,
tell the
that
truth.
is a yes or no question as to whether or not you affirm.
Not affirm.
I didn't ask you to take an oath or to swear. I asked you to affirm, which is a yes or a no.
That's a sin, I'm not sinning.
I'm sorry?
That's a sin, I'm not sinning.
Okay, will you tell the truth,
Yes,
the whole truth,
the whole truth.
under penalty of perjury?
Yes.
Thank you. You can have a seat, sir. Now, Mr. Hamada, you already are aware that you have the right to remain silent. Anything you say can and will be used against you. You are the defendant in this matter. You don't have any burden to prove here. The burden is completely on that of the prosecution. You've elected to waive that right and take the stand, correct?
Correct.
Okay, you may share with the jury the relevant information you would like them to have.
Words alone should not establish, words does not establish malicious intent. I called the reasons. And first it was polite reasons. The prosecutor not gonna bring that. Plus the prosecutor, she admitted that she was trying to get out. There was reasons that my uncle, you heard that part, that he was in prison for a gun charge. He had 8.5 years. And the other reasons was I was falsely in prison by Michigan 2 times. When I was at Maxi Boys Training School, I completed the program. And it's when I completed the program, the staff started putting me in solitary confinement for unwarranted reasons. And taking my visits from him, I was a minor. And I hit him because he raped me. And he just told it at that point in time, he just told I hit him and that was it, not the rape part. And I went to prison for that. And I asked the officer, the state, the FBI people to investigate the rape, the false imprisonments. And I actually called because I had a childhood lawsuit money in my right hand. The dog bite, I went over 60 grand. And while I was in prison, Jamie Diamond, the CEO of Chase Bank, and Chase Bank mismanaged and or stole my money. When I got out of prison, my money was gone. At first, I was on the state talking like, can y'all please investigate? And they gave me red tape. It was just red tape. And Ecclesiastes 7:7 says, surely oppression make a wise man mad. And my people being oppressed in America, I said harsh words. I mean, you heard the racism. I really just wanted justice. I didn't want to frighten or terrorize anybody. That was not. I have no malicious intent. I just want justice. I rest my case.
Okay, sir. You finished with your testimony, correct?
Oh yes.
Thank you. Cross-examination.
Thank you. The voicemails that are the subject of the court's case today are for two specific dates, July 18th of 2019 and August 16th of 2019. Do you understand that?
Yes.
You heard the voice messages as they were played in court today, is that correct?
Yes.
You heard the testimony that those came in relatively quick succession, a few minutes apart on the July date and about half an hour or so on the August date, correct? Is that a yes?
Yes.
Okay. And as you sit here today, you sound very calm.
Yes.
Do you agree that your demeanor today is different than it was in those voice messages?
It was just, I don't know what the meter is.
Your the way that you are behaving is a form of demeanor. Do you agree that your behavior today is different than the voice messages as we heard them from July 18th of 2019?
Yes.
Do you agree that your demeanor, way of being today, is different than it was on August 16th of 2019?
Yes.
Do you agree that the messages as we heard them for July and August were angry?
Yes.
That the language was vulgar?
Yes.
That it was indecent or obscene by some standards?
Yes.
Do you agree that that volume disturbed the public peace and quiet of the recipient of the voicemail?
No.
Why is that?
Because I don't know if he was disturbed.
Do you agree that if you received messages like that you would be disturbed?
No.
Why is it that you called so many times in a row?
Because I really wanted justice. That's all. My people getting shot by your people.
Object,
Sir,
I'm
there's
gonna
no-
object to
I'm
that.
gonna strike that last statement. You only can respond to the questions, okay, sir?
I'm sorry, did he answer yes?
Sir,
Oh, okay.
thank you.
Thank you. Now, sir, what justice would be received by saying, "You stupid white bitch, fuck Governor Whitmer, that stupid ass know nothing bitch, let my fucking uncle out of prison"?
If somebody said that to me, I inquire why. I would. I wouldn't just.
Okay, that was not the question. You need to respond to the question.
I thought I did.
Can you repeat the question, please?
Yes. What justice is served by that language?
Investigation.
What about when you say, "I pray to God that your motherfucking family is dead by the end of the day. Amen"?
Investigation.
Thank you. I have nothing further for this witness, Your Honor.
Mr. Hamani, did you want to redirect any of your previous testimony, meaning reiterate it based on those last questions?
It was an escalated series of phone calls. I even talked to somebody. You know, I even talked to him. I even told him, I think you want to investigate my rape. He said, no, I just care about my people.
Objection, Your Honor. Assumes facts not in evidence and is hearsay. There was nothing to that regard by Sergeant Leeds today.
Okay.
Sir, what? I'm sorry?
Can I correct you?
Okay, I'm gonna sustain the objection because you can't tell me what someone else said, okay? Or you
Okay.
can't tell the jury what someone else said.
I know, I told him all the false imprisonment, the rape, the stolen money, my uncle, I told him. And still to this day, no investigation. That's whatever you say. Still, I'm being prosecuted. I've been raped in about Michigan courts.
Your Honor, I'm going to object first to the relevancy of that statement as it relates to this case. And second, and I apologize, I didn't get it in quickly enough, but when he made the statement that there's no investigation, that assumes facts not in evidence. We don't know what, if any, investigation occurred by Detective Leeds as the incident before this court's consideration today is just as it relates to the two malicious use of a telephone charges.
Thank you. Mr. Marty, I'm gonna sustain the objection because you're assuming some facts that are not in evidence and you're stating that to the jury, okay? You don't know personally, sir, whether or not anything is being investigated. Do you know that personally?
Nobody told me.
Oh, okay, so the objection is sustained, okay?
Okay.
Any further argument about relevant information?
It's a double standard court.
Okay,
That's
thank you,
all.
sir. You
Your Honor,
can-
I'm gonna ask that that last statement be stricken. I don't believe that there's any relevance to that.
It's non-responsive. It's actually, it was inappropriate. I told you to say relevant information. This is not the time for you to give argument, okay? Sir, you'll have argument at the end, okay? You can go back to your seat, sir. Okay, and Mr. Hamadi, are you gonna be calling any other witnesses today?
No,
Okay, are you planning to present any additional information?
no,
Okay, so you're resting, is that correct?
yes.
Okay, thank you. We're gonna take a short recess so that we can do some housekeeping issues before we give you your final instructions. And you can go and be prepared for deliberation. So we're gonna let you go back to the jury room for now, okay? Okay, thank you. You can be seated, okay, and Ms. Houseman, before we get into jury final instructions, did you have any intention to call rebuttal witnesses?
No, Your Honor, thank you. I'm
Okay.
not.
Okay, thank you. So I will, did you both get a copy of the proposed verdict form?
I saw it this morning, Your Honor. I don't know that. I don't know that it's certainly not in my hands, correct?
Okay, can we get a copy of the proposed verdict form from both Mr. Hamadi and the prosecution? I am going to go and send or finish the final instructions. And I'm just basing them on the requests that you submitted, at least because we did not get any requests from the defense. And then we'll get you a printed copy of the final instructions, okay, sir?
Thank you, Your Honor. And I don't know, I'm just looking through mine very quickly to see if I included the defendant has a right not to testify.
That
So
is 3.03.
3.03 should be removed then, Your Honor. Thank you.
Okay. We will remove that, Mr. Hamadi. We're gonna remove that because you did testify, okay?
Okay.
And I think everything else should be fine, correct? Very good. Any other matters we should address before I go and finish the jury instructions?
Nothing for the people. Thank you.
Okay, thank you. You can be seated. Okay, ladies and gentlemen of the jury, we're going to go over some final instructions. Yeah.
Closing arguments.
Closing evidence, yes, and final instructions. Closing arguments and final instructions and rules of evidence before you go back for deliberation. The prosecution will give her closing statement, and then Mr. Hamadi, if he would like, he can give his.
Thank you, Your Honor. Well, ladies and gentlemen, as I said at the beginning of this trial, this is the opportunity that I have now to stand before you and make a closing argument, a final statement to the jury on what I believe that the evidence shows and how I think you need to take that evidence and apply it to the instruction that the judge is going to give you. Now, this was a different type of trial. The defendant elected to represent himself. And I understand that there were some things that were stated by the defendant that may cause you to feel a particular way. And I'm not asking you to separate from your human side, but what I am asking you to do is remember the burden and the job that you agreed to uphold at the beginning of this trial. I have no problem being held to my burden. In fact, I hope that you hold me to my burden because that's the only way that this system works. But my burden is to prove the elements of the charge and nothing else. And because of that, it's important that we understand that your role then is to look at the elements of the charge, the facts of the case, the instructions by the judge, and merge them. It is not to consider other parts of this case. It's not to consider other parts of the parties of this case. If you had a particular feeling about a witness, you wouldn't be able to take that into the jury room and say, I didn't like that guy. Now, you will get to assess credibility. You will get to assess memory. There are things that you will get to make a determination about, and you'll be instructed. But you don't get to take personal feelings into the jury room for either side. And that's important because you have to look at the evidence of the case as it is presented. So I'm going to ask you to keep that in mind as you weigh your decision. So what we have here, again, is back to those elements. What am I obligated to prove? Hold me to my burden. Let's go through it. So I have to prove that the defendant did maliciously use, I'm just going to go with a telephone. You all can read the instructions. I'm not attempting to change them, but you'll read through the definitions as the court will provide them to you. And that telecommunications device includes a telephone. You heard the testimony of Sergeant Luz that he made a determination because of the mobile phone carrier and the phone number listed that this was in fact a phone being used. So I have to prove that he maliciously used that telephone, that when communicating with Adam DeLay, that he either, remember all of that we walked through early afternoon about what our choices are, that he either threatened physical harm or damage to any person, not Adam DeLay, any person or property in the course of a conversation or message through the use of a telecommunication service or device, or that he used vulgar, indecent, obscene, or offensive language, or suggested any lewd or lascivious act in the course of a conversation or message through the use of a telecommunications service or device. And third, that he did so with the intent to terrorize, frighten, intimidate, threaten, harass, molest, or annoy Adam DeLay, or to disturb the peace and quiet of Adam DeLay. I understand what the defendant's testimony was, that he didn't have that intent. But what I'm going to ask you to do is decide whether that makes sense to you in light of all the other evidence. That is one of the very specific instructions that you're going to get from the judge. She's going to tell you that you don't have to believe all or any part of something that a witness says. You can decide that the person deliberately lied or just simply was mistaken. You can also decide that perhaps it's a memory issue and you're going to take some but not all. So that will be part of your job as the finders of fact, is to determine what evidence are we going to rely on, what evidence makes sense in light of everything else. You also did hear the defendant say today that things got escalated, that he wanted justice. Any way that you slice it, when you call on July 18th at 11:22 and 11:24 and 11:29, and you leave minutes-long voice messages where you use the language that you all heard and the statements that you all heard, that is not seeking justice. When you call on August 16th and you call at those 3 times again, call, a few minutes later, call, 15 minutes later, call, and you're saying and doing the things that you're not seeking justice. You heard the witness, Mr. DeLay, say, this is what we do. This is constituent services. It is our job to take walk-ins, phone calls, written letters, email communication, and to respond. That is our job. But you also heard him say that they couldn't even respond in this case because the messages were so angry and irate that they couldn't respond to them. This is not someone who called and left a message saying, my uncle is this person in this location, I want to talk to someone. Even if he had done so in an angry voice, frustrated, we might agree that that was justice. But when you call, and the opening line that you all heard was, I pray to God to kill Governor Whitmer and that stupid ass vice president and his stupid ass white bitch. I pray to God, kill y'all motherfuckers. Then we go to another voice message to Mr. DeLay. Whatever your name is, Adam DeLay or whatever, my name is Jamal Hamade. And it ends with, I pray to God that your motherfucking family is dead by the end of the day. Amen. And then we go to another message. And it says, and I'm going to come into your motherfucking every time I feel like it, nigga. Fuck you. Fuck you ain't picking up the phone for it, nigger. Know what I'm saying? What the fuck you mean? Pick up your motherfucking phone, dog. What the fuck you doing? You're a governmental employee, dog. Your job is to serve us niggers, dog. You know what I'm saying? Pick up your motherfucking phone, dog. This is not someone who had intent of anything other than harassing or annoying or disturbing the peace of Adam DeLay. You heard him say he recalled one message. Again, you're going to be able to make a determination about memory. You heard the detective say that he went in, he received 2 at first and 2 later that were received. Again, it's an issue of what do we have? What we have is the voicemails. You can hear the voicemails. I understand the demeanor that was presented in court today. I understand what his statements were in court today. But understand that you don't have to accept that. And if you as a jury feel that the intent is better shown by what was happening at the time, the length of time, the repeated voice messages, the multiple days, you can rely on that to determine the intent. And I hope that you do, because I believe that that is the evidence in this case. I believe that that is the evidence that shows that when he picked up the phone and made those phone calls, it was not to seek justice and it was not to have his questions answered. It was to do nothing other than annoy and harass the people on the other end of that phone. And I hope that as it relates to count one for July 18th, 2019, and count two, August 16th of 2019, that you will return the verdict that is just in this matter, which is guilty on both counts. And I thank you for your time.
Mr. Amani, any closing statement?
Malicious intent, the key phrase in this claim, in this claim. Please do not get caught up on anything the prosecutor say. If all that is presented today is just words, angry words, mean words, and hurt feelings, then there is no malicious intent. Malicious intent wanting to harm someone without justification by initiating contact to carry out your intents. If I can be convicted for cursing people out on the phone, then everyone who cursed people out on the phone can be brought up on charges. Key in on the law, and the law says I have to have malicious intent, and malicious intent cannot be established by words alone. And the prosecutor has only given you words alone. The prosecutor wants you to believe that I am guilty of the charges if I made the phone calls alone. That is not true. The law requires malicious intent beyond a reasonable doubt, and words alone cannot establish that. Jury instructions requires the intent to be malicious to render a guilty verdict. When I first heard these charges, I was willing to plead guilty until I saw malicious intent with that list. And I did not see that in me. I was not thinking that. I literally wanted justice. Thank you.
Okay, thank you. Any re-argument?
No, Your Honor, thank you.
Okay. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law as it applies in this case. Remember that you have taken an oath to return a verdict and just verdict, a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. I'm not sure what's going on. Okay. If a lawyer says something different about the law, or if the defendant says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or do anything. If you find that the prosecutor has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence include only the sworn testimony of witnesses and exhibits admitted into evidence, and anything else I have told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. The defendant's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyers and the defendant questions to the witnesses and my questions to the witnesses are not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you decide the case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during trial. As I said before, it is your job to decide what the facts of the case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any witness or any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might distract the witness? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to make an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently. Witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecutor must prove beyond a reasonable doubt that the crime or crimes occurred on or about July 18, 2019 and August 16, 2019 within City of Lansing, Ingham County. When you go to the jury room, you will take a written copy of the jury instructions with you along with your notes. You should first choose a foreperson. The foreperson should see to it that your discussions are carried out in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. As you discuss the case, you should think about all my instructions together as the law you are to follow. It is your duty as jurors to talk to each other and to make every reasonable effort to reach an agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you are in the jury room, please ask your foreperson to write a note and give it to my court officer. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in this case. As you discuss the case, you must not let anyone, even me, know how you're voting, therefore, until you return with a unanimous verdict. Do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you must, or you may take your notes and full instructions. If you want to look at any or all the reference documents or exhibits that were admitted, just ask for them. And so I'm going to give you a further instruction on that one. The only exhibits that was admitted was on a hard or a flash drive. So in the event that you all want to review that again, you won't be able to give you the flash drive. You'll have to come back in here and we can review it with you in the courtroom. When you go to the jury room, you will be given a written copy of the instructions you have just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. The defendant is charged with 2 counts, that is, the crimes of telecommunication services malicious use. These are separate crimes, and the prosecutor is charging the defendant committing both of them. You must consider each crime separately in light of all the evidence in the case. You may find the defendant guilty of all or any one of these crimes or not guilty. We have prepared a verdict form listing the possible verdicts, and you'll get a copy of that when you retire to the jury room. courtroom for deliberation. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statements as given to you. If you find the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. Facts can be proven by indirect evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So taking that same example, if you see a person coming from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence can be used to prove the elements of the crime. In other words, you should consider all evidence that you believe. The defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts and circumstances in evidence. You should not decide the case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard testimony from a witness who is a police officer or witnesses who are police officers. The testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. The defendant is charged with the crime of telecommunication services malicious use. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant did maliciously use a telecommunication service or device provided by telecommunication service provider to communicate with Adam DeLay. Second, that when communicating with Adam DeLay, the defendant A, threatened physical harm or damage to any person or property in the course of a conversation or through message through the use of telecommunication service or device, or B, use vulgar, indecent, obscene, or offensive language or suggested any lewd or lascivious act in the course of a conversation or message through the use of telecommunication service or device. Third, that the defendant did so with the intent to terrorize, frighten, intimidate, threaten, harass, molest, or annoy Adam DeLay, or disturb the peace and quiet of Adam DeLay. Okay, so ladies and gentlemen of the jury, that concludes the instructions. We'll make sure you get a copy of that along with the proposed verdict form. Okay. All rise for the jury to go and deliberate.
Your Honor, will you be swearing Mr. Bigelow?
I will.
Okay, thank you. My apologies, Your
Thank
Honor.
you. Can you raise your right hand? Do you solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors on the trial from separating from each other, that you will not suffer any communication to be made to them or any of them orally or otherwise, and that you will not communicate with them or any of them orally or otherwise except by the order of this court, or to ask them if they have agreed to their verdict until they shall be discharged. Thank you. The jury may be excused. Okay, we're in recess until the time that we have a verdict or unless we have a question from the jury.